want you to think about a question that we as law professors ask each other all the time. You're sitting in the faculty lounge, you're having your lunch, you're reading the newspaper, and somebody comes in. Joe comes in, and you have to make some conversation because it's Joe, and you work in the same place. Now, he sits on the other side of the building. You don't see each other very often, but what do you say? The easiest thing to ask is, Joe, what are you teaching this semester? And he says, I'm teaching Civ Pro. What are you teaching? And you say, well, I'm teaching evidence. And you chit-chat for a little bit, and that's the exchange. It's very common. I want to suggest to you that there's something in that short exchange that might tell us a little bit about how we see ourselves as teachers in a law school. To understand my general point there, imagine that you're teaching a capstone class. This is a fantastic new invention, if you will. At least it seems to be in the past couple years in legal education. The capstone class is a class that allows students to, or at least encourages them to think like real lawyers. Real lawyers hear a story and they don't just think evidence, 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 evidence. They think evidence, torts, forum, how do remedies work? Where will I file this lawsuit? Could there be an enforcement mechanism that takes me outside the country? All those different things are happening at once. That's complex legal thinking. We want students to get good at that. So you're teaching a group of 3Ls, and it's exciting because it's a wonderfully designed complex course, capstone course. And you started off with a great fact pattern. There's friends who used to be enemies, enemies now used to be friends. There's a business deal that's gone south, and, the business deal's gone south, and there's all sorts of causes of action, remedies, and issues galore. But there's one issue that's really, really simple, but you think, I'll just start with a softball. And the softball is, hey, everybody, before we get started on the meat of this question, why don't you just tell me where this lawsuit can be filed? In which state would we file this lawsuit? And that's a question of personal jurisdiction, if you happen to have forgotten that. But in this particular instance, it's very simple, and what do you get? You get a lot of blank looks. You get a lot of blank looks, and maybe that's not too surprising, but it's starting to occur to you that if this capstone course is all about putting the parts of the whole together, and students already have forgotten one of the most basic parts, you might have a very long semester. So after the first class, you decide to figure out what the hell might have just happened. And you say, maybe they just never really learned Civ Pro. So you track down their professor, and wouldn't you know it, it's Joe. And Joe, God bless him, he's a nice guy, but he's really not kept up with the times. He doesn't dress quite appropriately anymore. He makes weird comments in faculty meetings, and he's simply close to retirement, perhaps past the point of retirement, but he's still teaching. That's what you think anyway when you go talk to Joe, and it turns out Joe's teaching wonderfully. Joe's using some of the best stuff out there. He's reading all the journals, and one of the things he says to you is, oh yeah, we did personal jurisdiction. We did it at the very beginning of the semester. And you think, that's the problem, Joe. You didn't review it. He goes, no. I use what's called spaced repetition. You say, what's spaced repetition? He says, well, we learn at the beginning of the semester, 4 or 5 classes worth. We practice it then. Then about 2 weeks later, we practice it again. Another 3 or 4 weeks later, we practice it again. And by the end of the semester, the students really, really know it. And you're like, well, how does that multiple spacing work? He goes, well, if you sort of start to forget it, but you practice it again, it pulls it back and it makes the memory stronger. And that's durable knowledge. You have knowledge that you have right at this moment that you can use, but it may not last. Durable knowledge comes about often through spaced practice. And Joe says, I can tell you, I looked at their final exams. Those kids really, really knew it. So you say to yourself, my capstone course is not particularly working, or at least I'm not optimistic about it, but it's not Joe's fault. Maybe it's the students' fault. Well, we can hardly blame the students, right? Joe did a fantastic job teaching them. They knew it as of, let's just say, December of their first semester. We can't expect them to review it on their own, do we, right? They have all sorts of other classes we're demanding of them. And so it's not the students' fault either. So then whose fault is it? Before I suggest whose fault it might be, I want you to consider a solution to this problem that you face in your capstone course. It's a course that I think might be worthwhile for my law school and lots of other law schools to create. It's something we might call a fundamental concepts course that would be taught in the second and third year. It'd be a course that it consists of 1, 2, maybe 3 credits, and would contain a bunch of information that was taught in first-year courses. All right, so you might have a 2-credit course that covers torts, contracts, and procedure. And you think to yourself, how in the heck could you teach all that stuff in 2 credits? That's ridiculous. It sounds ridiculous until you remember the Fundamental Concepts course is a course that tries to take advantage of the concept of spaced repetition. When Joe taught personal jurisdiction initially, he spent 4 or 5 classes on it. When he came back to it 4 weeks later and then 6 weeks later, he spent half a class. The students spent a lot of time at home, 2 hours maybe working through some problems. But they reviewed personal jurisdiction and got back up to 100% knowledge at that point with only 30 or 40 minutes. I teach bar review courses in the summer, particularly civil procedure, and I'm telling you, I can bring you up to speed on personal jurisdiction in 20 or 30 minutes as long as you do some work on your own, right? Now, you won't have deep knowledge in the sense that you can brief an important case or analyze a bunch of very complicated facts. But remember, that's not what we're going for in spaced practice. Spaced practice is to keep you from forgetting what you already knew. We gave you building blocks in your first year of law school. They started to crumble. Now they're turning to sand, and we can't build anything on sand. Okay, so let's return to who's at fault. If you indulge my claim that a fundamental concepts course will work and is important and even indeed necessary to your course, then who's at fault? It's you and everyone else at your law school who has the ability to create or advocate for the creation of a course that would solve that problem. On law faculties, we're like players on a ball field. We each have individual positions, but we have to work together. If you work at a particular position and you have a great game on the field, but we lose, we still put that in the loss column. If Joe teaches civil procedure like a champ, but our 3Ls still don't understand the basics of personal jurisdiction, then the faculty has lost the game. So, let me return to that simple question. What are you teaching this semester? I'm teaching Civ Pro. I'm teaching evidence. It's a simple and frankly a harmless colloquy. But I hope that when we answer that question, we realize that we are not just teaching civil procedure itself, but we are part of and owe a responsibility to the larger project of teaching happy, healthy, and talented learners. Whether we realize it or not, we are always team teaching. Thank you very much.